Welcome to this video on deportation as a defense and why permanent residency in the United States is not absolute. We will explore how criminal convictions, especially domestic violence, controlled substance offenses, and aggravated felonies, can place lawful permanent residents at risk of removal. We will also discuss safety-first strategies for victims, how law enforcement actions can trigger immigration proceedings, and practical documentation tips. This video is for general information only and is not legal advice. In this agenda, we will first clarify myths about permanent residency. Next, we will cover the main removal grounds, including domestic violence, controlled substances, and aggravated felonies. Then we will explain how law enforcement actions and ICE detainers can lead to removal proceedings. After that, we will provide safety strategies and documentation tips for victims. Finally, we will close with key takeaways and quizzes to reinforce learning. This content is educational and not a substitute for legal advice. If you are in immediate danger, call your local emergency number, which is 911 in the United States. The National Domestic Violence Hotline is 1-800-7-997-233, and the hotline.org. You need legal advice. Consult a qualified immigration or criminal defense attorney. For victims, safety planning is essential and should be done discreetly and with professional support where possible. We begin by addressing a common misconception that a decades-old green card guarantees immunity from deportation. In reality, permanent residency can be challenged when certain crimes are involved. Domestic violence convictions can directly create deportability. Old drug charges may reappear during fingerprinting, biometrics, or naturalization applications because databases retain those records. Aggravated felonies are particularly serious and often limit the ability to seek relief from removal. This flowchart illustrates the typical path from a domestic incident to possible removal. It begins with an incident and a police report, which may lead to arrest and criminal charges. The key decision point is the criminal court outcome. A conviction for a deportable offense can lead to jail or transfer situations where ICE may lodge a detainer. ICE can then issue a notice to appear, initiating immigration court proceedings. At that stage, the person's eligibility for relief is assessed. The process can end in a removal order or relief being granted. There is also a branch where an old controlled substance conviction is discovered during biometrics and directly triggers immigration proceedings. Multiple police visits alone usually do not cause removal, but they can bring attention that leads to arrests or deeper review. This section maps the main deportation grounds relevant here. A single conviction for a crime of domestic violence can make a permanent resident deportable. For controlled substances, prior convictions still matter under immigration law, even if they are older. There is a narrow exception for a single offense involving less than 30 grams of marijuana for personal use. Aggravated felonies, including certain violent felonies, are among the most serious categories and sharply restrict available relief. Violations of protective orders, stalking, and child abuse offenses are also grounds. Documentation of escalating behavior, such as use of weapons, strangulation, or threats, can affect prosecutorial decisions and immigration consequences. On the left, we have the perception that old charges are resolved, records may be sealed or expunged, there has been no recent police contact, and the physical green card is still valid. On the right, the current risk remains, because biometrics and federal databases can surface old convictions during applications or after arrests. Immigration law may not recognize expungements the same way criminal courts do. Filing for naturalization can trigger thorough background checks. Finally, the physical green card's validity does not prevent removal when a deportable conviction exists. This table gives quick statutory references. Crimes of domestic violence, stalking, and child abuse or neglect fall under INA 237A2E, where a single qualifying conviction can establish deportability. Violations of protection orders fall under INA 237A2E. Controlled substance offenses are under INA 237A2B. With a narrow exception for a single offense involving less than 30 grams of marijuana for personal use. Aggravated felonies are defined in INA 101A43, and deportability for such convictions is under 237A2A. These provisions often severely restrict eligibility for relief from removal. Prioritize safety by creating a discrete plan that includes shelters or secure housing. Prepare essential items and copies of important documents, such as identification, protective orders, and medical records. Practice technology safety by disabling location sharing, securing accounts, and using private browsing when needed. Set a code word with trusted contacts. Consider pursuing a protective order if it can be done safely and in accordance with local procedures. Engage domestic violence advocates who can assist with safety planning and legal referrals. Document incidents carefully, including photos, medical notes, messages, and police reports, stored in a secure location. Law enforcement can serve as a catalyst for immigration action. An arrest for a deportable offense can lead prosecutors to file charges. If the individual is convicted of a deportable offense, this establishes strong grounds for removal. ICE may then issue a detainer, potentially leading to transfer or continued custody.
The process continues with a notice to appear, which begins immigration court proceedings.
At that point, eligibility for relief is assessed.
Aggravated felony convictions greatly limit available forms of relief.
Question: does having a decades-old green card guarantee immunity from deportation? Options: 1. Yes, it guarantees immunity. 2. No. Serious convictions can still lead to removal. 3. Only if the person has lived in the U.S. more than 20 years. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is no. Serious convictions can still lead to removal. Permanent residents remain subject to the immigration laws on deportability, and certain convictions can trigger removal proceedings. Victims may have several avenues for protection, including VAWA-based immigration relief and U visas for victims of qualifying crimes who cooperate with law enforcement. State protective orders may provide immediate safety measures. It is crucial to consult experienced legal counsel to coordinate criminal, immigration, and safety strategies in a way that minimizes risk. This timeline shows the typical sequence from the incident and reporting through medical documentation, arrest, and criminal court. After a conviction for a deportable offense, an ICE detainer may be issued, leading to a notice to appear and immigration court hearings. The process then leads to either a removal order or relief being granted. There is also a side note that an older drug conviction may be discovered during biometrics, such as in the naturalization process, which can trigger the issuance of a notice to appear. Maintain a chronological incident log with specific dates and facts. Save relevant photos, text messages, and call logs, but store them safely, preferably off the device. Obtain medical records, and ask providers to document the cause of injuries when it is safe to do so.
Request copies of police reports and record case numbers.
Back up all materials to a secure location, such as a protected cloud account or a trusted contact.
Share these documents with legal counsel to support a coordinated strategy.
Question: which of the following is often sufficient by itself to create deportability for a permanent resident? Options: 1. A conviction for a crime of domestic violence. 2. A single offense involving less than 30 grams of marijuana for personal use. 3. A parking ticket. 4. All of the above. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is a conviction for a crime of domestic violence. That can be a direct ground for deportability. The marijuana exception covers a single offense involving less than 30 grams for personal use, and minor infractions like parking tickets do not create deportability.
The key takeaways are that permanent residency is not absolute in the face of certain criminal convictions. Domestic violence, controlled substance offenses, and aggravated felonies can lead to removal. Old convictions can resurface during background checks and biometrics. For victims, safety planning and thorough documentation are critical. Finally, legal counsel is essential to align criminal defense strategies with immigration consequences. In summary, understand that while permanent residency provides significant status, it does not shield against the immigration consequences of certain criminal convictions. Prioritize safety through distance, shelters, and protective orders when appropriate. Maintain strong documentation including logs, reports, and records. Seek legal counsel early to align criminal and immigration strategies. Thank you for watching. Please like the video, share it with anyone who may benefit, and subscribe for more content. Share your questions or experiences in the comments. Your input helps others and guides future videos.